Hello and welcome to this webinar on the OREC Buyer's Agency Agreement. I'm Bryan Hutchinson. I'm joined by Jace White, General Counsel. We know that some of you are a little bit anxious or feeling some angst around the transition to using the Buyer's Agency Agreement on a more regular basis. And so we wanted to take some time to offer this webinar as an instructional opportunity for you to get more comfortable with it. This will be a combination of two different things. Jace is going to cover some legal aspects of the contract, some things that you really need to pay attention to. I'm going to work and talk to you a little bit about some best practices or common sense approaches to how you utilize this contract in a way that helps you and the consumer really come to a meeting of the mind about what's happening. What I do really want to encourage you to remember is that in our industry, change is inevitable. We are always facing change. I know there's a lot of people who are concerned that buyers aren't going to want to sign this document because they're not used to it, because they haven't done it in the past. I want to remind you that we look at real estate every single day. We're in these contracts every single day, and to us that becomes a real normative change. But the average consumer doesn't look at real estate contracts or transactions every day. In fact, there are 5 to 6 years in between those transactions, and a lot of things happens in 5 to 6 years. So we want to encourage you to accept this buyer's agency agreement as a tool to help you better communicate with your clients, help understand the different roles that people play, and ensure that all of the aspects of what you negotiated have been covered. So as we get ready to go through that, Jace is going to talk to you a little bit about what this webinar is not.
Thanks, Hutch. I appreciate that. To Hutch's point, we're here for a webinar today that is not being offered as legal advice. We're going to be talking a lot about best practices today. That does not mean in any way, shape, or form that Oklahoma Realtors is any way suggesting that there's only one way to do business or one set of practices that you have to follow. Again, my reminder to you is to always talk with your broker, figure out what their practices are, what their policies are, and just make sure you're working with them to figure out what that looks like.
So with that, we're going to dive right into paragraph 1. Jay's going to talk a little bit about the legal side of that, and then I'm going to talk a little bit about some best practices in response. Jace?
Very good. Thanks, Hutch. All right, so yeah, paragraph 1 of the buyer-broker agreement from OREC is largely a carryover from that buyer-broker agreement that previously existed before these changes. It outlines what the purposes of this agreement are. It outlines what the expectations of the parties to it are. And that includes several responsibilities that you're expected to comply with as far as the services that you'll be providing pursuant to this agreement. I know Hutch has some thoughts on best practices for that.
I do. And so one of the things I'd like to say to you about paragraph 1 is that this gives you, from a best practice perspective, the maximum opportunity to demonstrate the value you bring to the table. Consumers don't really realize what all you do. In fact, when you look at how this is designed, you'll see that there's specifically 7 different statements that are made inside of this buyer's agency agreement. Those are deliberate. Those are on purpose. Those statements are in there for you to have the opportunity to explain to the buyer what exactly it is that you do, what you bring to the table. Additionally, we want to let you know about a form that you may or may not know of. It's on nar.realtor that you have access to. It's a document called 179 Ways That Agents Who Are Realtors Are Worth Every Penny. We'll make sure that you have a copy of that link directly to it. It's a phenomenal document to download to help explain what it is that you do. Remember, transparency is of the utmost importance. This is where you're going to demonstrate your value. That's what paragraph 1 is really all about.
No, wholeheartedly agree, Hutch. Jumping straight into paragraph 2 here, again, this is very straightforward. This is an acknowledgement by the parties that a written agreement must be entered into before the broker can show the buyer a home. Again, it's a really straightforward practice change that's kind of coming into the ether as of late. And again, pretty straightforward on that.
Yeah, I think a best practice here is to demonstrate uniformity. I might say something like this. These aren't, I have to use my words, but I might say something like this. This form is generated by the state of Oklahoma. If a realtor is acting ethically and follows the rules, you'll have to sign this form or another agreement like it before they can show you any property. A simple, straightforward, truthful statement about the purpose of this form will be a great tool for you to use.
Absolutely, Hutch. Jumping into paragraph 3 now, this language serves fundamentally as a representation of the buyer, that the buyer is not working with and is not party to an active broker agreement with another broker. There's a lot of benefits from having this type of disclosure and representation in the buyer-broker agreement. You all are all familiar with Article 16. As you know, Article 16 prohibits realtors from taking any action that's inconsistent with an exclusive representation agreement that another broker or another realtor has in place with the client. If you're working with a client in signing this buyer-broker agreement, have that conversation with them. Ensure that they understand the representation that they're making to you. And again, this gives you some credibility in saying, hey, this buyer signed this buyer represented to me that they weren't working with anybody. And in terms of Article 16, that's what we're focused on there, right? Is to ensure that we're not willfully interfering with someone else's agreement.
Yeah, and let's talk about this from a common sense perspective for just a second. You know, here's a reality. Buyers may actually end up signing this form with several different buyer's agents. You, as a practitioner, have no control over that whatsoever. So it's your obligation, your duty, to make sure that you've dug in a little bit, you've asked a question. And if you find an indication that somebody may have signed one of these forms already, don't hesitate to ask for a copy of it so that maybe you can look at it and see if there's any special provisions like exclusivity or non-exclusivity or a specific town or geographical limitation. Those are some things we're going to talk about in just a minute. But the key part to this section is for you to get the most comfort you possibly can that the person you're trying to represent is not represented by anybody else.
Yeah, absolutely. Couldn't have said it better. Jumping into paragraph 4 of the OREC agreement here, this concerns the buyer's affidavit that is going to be part of closings moving forward in the state of Oklahoma. As I'm sure most of this audience is well aware, the state law has changed in recent years regarding Title 60 sections 121 and 122. What it requires is that a buyer, when going forward with a closing and working to purchase a property, they have to sign an affidavit and record an affidavit in order to record their deed, which fundamentally says that they're allowed to purchase that property. This language in the agreement ensures that the buyer is aware of that requirement, and again, it's a jumping off point from a conversational standpoint for you to be able to talk with your buyer and ensure that they're going to be able to sign that affidavit when it comes time.
Yeah, and so, listen, this is one of those key points as well in being congruent with the law. You're going to get to the closing table. If they can't legally sign, they can't legally sign, and that's going to mean that you've done a lot of work for no reason whatsoever. So I might consider using a statement something like this. My words, not yours, but perhaps you want to say something like, Mr. and Mrs. Buyer, when I work for you, when we find the right property, when we negotiate the right deal, will you be able to legally sign this affidavit? And simply ask them that question. Get their agreement to it, because when they sign the buyer's agency agreement, they are making the statement that they can, in fact, sign that affidavit and legally purchase properties inside the state of Oklahoma.
Yeah, absolutely. Jumping into paragraph 5 now, make sure I get the right slide up here. So again, this concerns the duration of the agreement, really governs the length that this agreement is going to be active. It provides for a blank for you to insert a start date, and as well as an end date. Again, by default, if you include no language in that agreement, it's going to last for 60 days. Again, you're free to enter into whatever agreement for whatever length that you would want, provided that you comply with the law. I would tell you that in recent years, the change has come about through OREC's legislation that's coming up this year that prohibits entering into exclusive representation agreements for longer than a year. So remember that cap of 12 months as you're working through this.
Yeah, let's talk about some best practices around this, because I think you will find, with a little bit of due diligence, that paragraph 5 is really intended to help both the consumer and the agent to discover some protections that you may not readily see as you just read the form. Again, those 2 dates are important. You know, we came up with this argument all the time, nobody's gonna sign this form. Well, yes, they will. They will sign this form because it'll become common practice. It'll become part of what they're gonna do. So let me tell you some things you can do. You could choose to sign this form for just 1 day. In fact, if you so wanted, you could choose to have this agency form in place for just 5-minute period of time by simply putting in a time on the start, the beginning, and the end dates, along with the date. I would recommend, or I think that you may want to consider having a period of time no less than 4 days. And the reason for that is what takes place with the termination. This document is able to be terminated by the buyer or by the agent with 3 days written notice. So if you have a minimum of 4 days and that person, that buyer wants to terminate that, that gives you a 3-day window to act. They might be saying, act, what do I have to do? By law, you don't have to do anything. But a good common sense practice might be to recognize in writing, perhaps through the sending of an email or other written communication, that you've received the termination notice, and to list out the properties that you believe you might be owed a commission on, that you believe you're the procuring cause of sale on. Now, I don't want to hone into this for a long period of time, but that doesn't necessarily mean every property that you've sent them to look at through the internet or that they've found on your website. But maybe those properties that you've actually taken them to see, that they've indicated interest in purchasing, you're going to want to memorialize in an email that you've shown them those properties and you believe that you're entitled to a commission. Because as you'll see later on in this agreement, the wording has been made in such that whether it's terminated or whether it expires, that you have protections against that, for that work that you've already done. So Jace, could we talk about a couple scenarios real quick?
Absolutely,
around
yeah.
when this duration of the period might come into play, and about when they actually need this agreement in place?
Absolutely.
So let me give you a couple. First scenario. An individual calls from a sign. You have a property listed, there's a sign in the yard, they driving by, they see the property, they call from the sign. Do you have to have this form signed and in place before you give them any information about that property?
Yeah, I would say no, Hutch. And the reason for that is because at that point, if you've got a sign in the yard, you're working with a seller, you're working with that seller. It is incumbent upon you to use your best efforts to try to sell that property. And so if you have an unrepresented person call and ask for information about that property, that necessarily implies that you're going to need to give them that information.
Which is a very important point to remember about agency in the state of Oklahoma. A person does not have to be represented to enter into a real estate contract to see property. There are buyers who will not want to be represented, in which case you still represent the seller of the property solely. And so you're allowed to provide that information. In fact, you're required to provide that information. What about this scenario? What about the person who's on their tablet at 11 o'clock at night and they're on a third-party site like Zillow or Realtor.com. They find a property and they're smart enough to look at who's got it listed as opposed to click here and for the buy the realtor lead. They contact you through that listing. So they find the property. Now they're seeing pictures of it, and they want inquiring of more information about that property. Do they need the buyer's agency form to be signed for you to give any more information about the property on that type of a phone call?
Yeah, I would say no. I think the answer stays the exact same. I think you still have an obligation to give that information as quick as possible to that person in the name of representing your seller at that point.
Yeah. And then one more scenario. Let's take that a step further. They call off the sign or they call off that third-party data. You give them information about the property, and then they indicate to you that they want to go see that property, like hey, we've got to get in and see that property, and they ask, can you show us that property? Can you bring us in? What's the step that an agent should take at that point in time?
Yeah, no, it's a great question, Hutch. And I think that the answer really is you've got to ask a follow-up question to that buyer. You've got to figure out first, is that buyer working with an agent? If you find out and they answer yes, I am working with a buyer's agent, then refer your communications to the buyer's agent and set up that showing and proceed forward. If you find out that the buyer is not working with an agent, then I think the follow-up question is, are you wishing to proceed forward unrepresented, or are you wishing to have representation as you come and see this property? If they say they want to proceed forward with no representation, they want to represent themselves, that's perfectly fine. They're allowed to do that, and you have to, again, work for your seller to make that happen at that point. But if they are wanting representation, it gets a little more difficult and a little more complicated. You need to start working with that seller to ensure, hey, are you wanting to be represented by me? Is that going to be with me? If that's the case, then I'm going to need a buyer agreement signed before we proceed forward with the showing.
Yeah, and to be clear, you're talking about buyer, not the seller, which is paramount, because if you represent the seller, you've already reached those agreements with them. I want to make sure that people don't overly complicate this, because I think this is a point where our members are starting to feel a little bit of angst, right? Like, how do I get this done? If somebody says that they want to be represented, or maybe they say if they want to be represented, it's straightforward, fill out the agreement and make sure it's clear and it indicates everything. If they may answer and respond to you, I don't know. We're interested in seeing the house. We don't understand what the process is. Those are some kind of keys for you to really dive in. Those are the points where you really need to, again, demonstrate your value and have the conversation. That's all it is a conversation. Remember, the form was purposely generated to give an incredible amount of flexibility in how you fill it out. That start time and that end time for this form, again, may be just for the one house. It may be just for that one property, and that's the stepping point to turning that cold call from a sign or from an internet into a lead to represent as a buyer, either for yourself or for somebody else in your brokerage firm, depending on your broker's policy. And so let's talk a little bit about termination, paragraph 6, Jace.
Yeah, absolutely. So as Hutch was mentioning earlier, in paragraph 6, we do have a mutual right of termination in this contract. Either the buyer or the buyer's broker can invoke that by giving 3 days written notice to the other side that they wish to terminate the agreement. I would caution you, however, that there's a caveat. The right of termination cannot be invoked by the buyer if the buyer is under contract. So the buyer needs to be aware of that fact, that once it's under contract, they cannot terminate the agreement at that point.
Yeah. So let's talk a little bit about some of the best practices here, because I think there's a couple of things that our agents can do, our members can do, to really protect themselves as well as protect the consumers. First and foremost, best practice is making sure that you use a reasonable amount of time for those blanks. When you're talking about when this is in duration, in paragraph 5, make sure it's a reasonable amount of time. Now, the Real Estate Commission has already given you a hint as to what they believe a reasonable amount of time is. The Real Estate Commission has put in this as a blanket statement, 60 days. That tells me there's an indication they believe 60 days is a reasonable amount of time. We're working, legislation is being changed in the state, and that's going to, has increased to a year as a maximum term, but 60 days may, plus or minus, may be a good common sense best practice. The second thing that I want to say to you is that when you either give a termination notice or you receive a termination notice, there's a 3-day window that exists. That 3-day window is very deliberate and very purposeful. That gives opportunity for either party to give information or share information back and forth that may be pertinent to future transactions. So let's play that scenario out for just a second, Jace. I'm a buyer's agent representing a buyer. You're a buyer of a property, and you say, and I take you to see 123 Main Street, and you absolutely love 123 Main Street. I can see it, you and your beautiful bride, this is where you want to be the rest of your life. And then that afternoon, I get back to the office and you send me a termination notice. A best practice in a scenario like that might be to say, I should probably make sure that my buyer, that I've signed a buyer's agreement with, understands that if they purchase 123 Main Street within the time that's covered under the expiration or the termination agreement, that they are going to owe me commission. So how would we memorialize something like that? What are some ways that they could memorialize that, that belief that a commission would be owed?
Yeah, I think you can memorialize that pretty simply with just giving a written notice. While that termination is sitting out there, again, you've got that 3-day notice period. It's a great time for you to type up a list of properties, whether it's only 123 Main Street or if you showed them 4 or 5 properties during that time, to say, hey, just so you're aware, if you purchase one of these properties within the next 60 days or whatever date you've inserted into the contract, I am still owed my compensation under this agreement. So that the buyer knows and understands at that point that if they go to close on one of those properties or even contract on one of those properties, that there's going to be an expectation of compensation from the buyer's broker waiting out there. Yeah.
Yeah, and in the rare occasion that we think will be rare occasion that there becomes a demand on commissions or a dispute between real estate agents or practitioners about who's owed what, that documentation is going to help with the procuring cause of sale issues when and if that goes to an arbitration or mediation. So it's just a best case scenario,
Absolutely.
right? Best practice to do. Again, visit with your broker. This is not legal advice. Talk to your broker about that. But that paragraph, that termination agreement, is really there to protect both parties, and it gives some opportunity for both parties to do some documenting as to what they believe the future looks like after the termination. That's enough about that. Let's move on to paragraph 7, which is compensation of the broker. Jace, I know that we should probably at this point in time make another really clear caveat, disclaimer statement. I'll do that for us. I want to remind everybody that Oklahoma Realtors has nothing to do with establishing commission rates or compensation. Compensation is simply and solely a matter of contractual agreement between sellers and brokers, buyers and brokers. Those are handled by the policies of your local brokerage firm. If you have any questions about amounts or dollars or rates, take those to your broker. We have nothing to do with establishing any rates. So if in this common sense conversation we're having, to do justice to our members, we're probably going to use arbitrarily pull up imaginary numbers or imaginary percentages. Those are simply for illustrative reasons only. They are not in any means intended to fix the market. As legal counsel, can I make that any clearer?
I believe it's been made very clear.
Okay, good, Jace. Well, why don't we talk about the compensation, paragraph 7.
Yeah, absolutely. And so this is where a lot of the meat is to these changes in the buyer-broker agreement here in paragraph 7, and we'll hit it again in paragraph 9. But paragraph 7 is the paragraph which does, well, it does a lot of things, okay? First and primarily, it governs the compensation that's going to be paid by the buyer to the broker. Again, we're going to deal with compensation that's being offered and paid by either the seller or the listing broker later in paragraph 9, but again, think of paragraph 7 as focusing on the compensation coming from the buyer. It serves as an acknowledgement by the buyer that the compensation is fully negotiable and it is not set by law. Again, we really want to make sure that that is abundantly clear to buyers as we move forward in selling real estate. It also clarifies that the buyer-broker agreement that we're talking about here, this entire document, and I'll use OREC's language here, is not enforceable if this section is not filled out. What that means, and what I would interpret that to mean, is if you work through every other piece of this agreement and you sign it at the end, it is not going to be enforceable if you have left paragraph 7 blank. So you need to just tread carefully and ensure that as you're entering into these contracts with buyers and fully negotiating them, make sure that you have a selection marked on paragraph 7 and actually fill that out. The other thing that paragraph 7 does is it contains 3 options for the manner in which a buyer's broker is going to be compensated. And I'm going to just take those one at a time here. Box A, this says that the buyer agrees to compensate the buyer agrees to compensate the broker at closing, and it gives a few options for doing so. It's got a blank for inserting a flat fee. It's got a blank for inserting a percentage of the final sales price. And importantly, it gives the buyer a credit for any cooperative compensation that's offered by the seller or the listing broker, and that credit would be observed at closing.
So what I would say about that as a common sense practice on 7A, number one, make sure that the buyer knows that this is the maximum amount that you are going to work with in this transaction. And so whether you're using a dollar amount or a fixed percentage, make sure that they understand this is the maximum amount. So when you're talking about who has to pay and when it has to be paid, they're aware of what this dollar figure is. And I'd also give them some examples. So in example, if I had a buyer that was looking to purchase a $200,000 property, I would multiply out, I would do the math if it was percentage based, figure out what that maximum amount of commission would be, and explain that to them. If you buy a $200,000 property, that means that you're going to owe me X amount of money in correlation to that percentage. So I would make sure you explain that in great detail.
Yeah, absolutely. Again, so that's just one option, and it may be the option that's primarily invoked by folks choosing to utilize this agreement. Again, there's an incentive for a buyer to desire, a credit to these type of in these situations. But there's also a couple of other options here. Box B covers situations where a buyer's broker is wanting to receive a retainer fee. The language clarifies that retainer fee is applied at closing, and it also clarifies that in the event the transaction does not close, that fee is not refundable.
So from a best practice perspective, what I would say is be very careful about how you use retainer fees, and make sure that you follow your brokerage policies. There are some caveats in the law specifically that deal with retainers and how you use them. This is written to protect that it is a non-refundable retainer, and that's intended to give protection to the buyer's agent and the buyer's broker for their work to guarantee them. But again, a retainer is going to be new or uncharted ground for many of you, so make sure you follow your broker's policy on utilizing them.
Yeah, absolutely, wise words. Turning back to this final section here, we've got a box C. It's a very blank section that allows the parties a lot of flexibility about how the compensation is going to work under this agreement. Again, you're free to work with the buyer and freely negotiate language to put in that section, but I do want you to remember a couple things here. And the big thing here is your compensation that you're receiving under this agreement must be objectively ascertainable, and it cannot be open-ended. So whatever language you choose to utilize in putting in this section, if you choose to use it, you must ensure that you're not receiving an amount that is more than otherwise stated in the agreement, and that the amount of it can be clearly arrived at in an objective and ascertainable way.
Yeah. So a couple of follow-up things on the whole compensation thing and negotiating. All compensation is negotiable in real estate transactions here in the state of Oklahoma. They're negotiable. I want to remind you though that negotiation is a two-way street. A negotiation at the end represents the meeting of the mind of two parties. And so your brokerage firm, you as a practitioner may set specific rates. You may have identified your value, what you believe you bring to the table, and what the minimum amounts that you're going to work for or the maximum amounts that you're going to work for, and that may have established a range. And that might be different on different properties. That might be flat scales that go up by different price points, or it might be percentages that change based on different levels of service. It doesn't matter. Negotiation means a meeting of the mind. Just because one person wants to negotiate a lower rate does not mandate that you as a buyer's agent have to agree to work for that lower rate. It's your choice as much as it is the buyer's choice. The biggest thing is that this document, the buyer's agency agreement, memorializes the meeting of the minds. It puts into writing, it condenses down into written form in a very basic sense what you've agreed to do. And whatever it is that you've agreed to do, my best common sense practice for you is to do exactly that. Let's talk about paragraph 8 a little bit.
Before we jump to paragraph 8, I've got one little bit of
Sure.
language to hit on here at the end of paragraph 7. There's a large paragraph there underneath sub C, and that harkens back really to this concept of termination and this 60-day protection period that exists by default in the contract. This language, in my opinion, makes it abundantly clear that that situation, that protection period, applies not only to situations where there's a termination, but also to situations of expiration. So let's say you have a 3-month listing agreement here, and once that expires, that 60-day protection period, as concerning properties that you've worked with and shown a buyer during the term of the agreement, it continues on in that setting as well. So you're protected both with a termination and an expiration.
Good, thank you, Jace.
Yeah, absolutely. You care if I just jump into paragraph 8?
Go right ahead, please.
All right, very good. Let's see here. So paragraph 8 addresses 2 situations regarding a failure to close. Basically, the 2 situations are where the failure to close is caused by the seller or where it's caused by the buyer. If it's caused by the seller, the agreement contemplates that the compensation that's previously identified in paragraph 7 will not be owed by the buyer, and more or less you're starting over as a blank slate with your buyer. However, if the failure to close is as a result of the buyer or a breach of contract by the buyer, it protects the buyer's broker in the sense that that compensation owed, or the compensation identified in paragraph 7 will still be owed. So,
Yeah, and a best practice on that is to make sure that you have a written agreement about what's going on. Really consider the retainer and the effects of a retainer on that. And by the way, you also need to consider whether or not you plan on continuing to work. So let's say that the buyer defaults and they owe you the commission on that property, but in their default, there really was a valid reason for it and they want to continue working on. You're going to have to make those kind of decisions. That's going to be largely based on the policies that you have in place, the understandings you have in place with your broker, and what their direction is. Pretty straightforward.
pretty straightforward, exactly.
Paragraph 9?
Paragraph 9 is not less than straightforward, it's just more to it. So much like paragraph 7, again, is a pretty bulky paragraph, and again, as mentioned earlier, this is dealing with compensation that's being paid or offered by sellers or by listing brokers. Again, it does a few things. It governs that type of compensation offered from the sell side. It clarifies that sellers and listing brokers are not required to offer any cooperative compensation or incentive or anything like that on these transactions. And it underscores the fact that buyer's brokers cannot receive more total compensation under these agreements than what is otherwise identified in paragraph 7. So those are the few things that it does, and I would say that it also addresses a few scenarios. The first scenario is contemplated there in subparagraph A. It says that, or it deals with a situation where the amount of compensation that the buyers agreed to pay is equal to the amount of compensation that the seller or the listing broker is agreeing to pay. Result, pretty straightforward. The buyer owes no compensation at closing because all of that, as mentioned, is going to be paid by the list side.
Yeah, so let's talk about language related to 9A for just a second. I think this is, from a common sense perspective, this is an area where buyers' agents are going to really want to be careful with their words, probably going to want to come up with a straightforward line that they use time after time after time to explain it. I've thought through that, like how would I explain that if I were doing it? And I think the language I might use, certainly not something I'd tell anybody that have to, would be to say something like this. The seller or the listing broker are not required to offer any forms of compensation. However, historically, compensation has been offered sufficient enough to cover my fees. I might say something like that. I might say to that buyer I'm working with, historically, I've always been able to get my compensation from the seller, if that's an accurate statement. Or the greatest majority of times I've been able to obtain my compensation from the seller. A historical statement like that is fine. I would be very careful about using words like normally, and I'd be very careful about correlating that back to the market as a whole. remember, you want to specifically here in this paragraph talk about you, your brokerage firm, and your practice, not what the market as a whole is doing. Talking about your experience related to how you represent your buyers in these areas.
Yeah, absolutely, well said. We're gonna turn over to subparagraph B here, which addresses a different type of situation, and probably the most complex situation that agents may find themselves in. And it's where a buyer has agreed to pay a certain amount of compensation under paragraph 7. But you find out that either the seller or the listing broker is offering more compensation than that offered, or than which is delineated in paragraph 7. The result of the contract is that the buyer and the buyer's broker are required to enter into a written agreement about what exactly do we do with this overage, this excess compensation that's being offered over and above what's in paragraph 7. And the agreement gives us a couple of options here. One is a credit to the buyer in that situation. One is a credit to the seller. And the third is another option negotiated and agreed to by the parties in writing. I would like to stop and talk a little bit about renegotiation. There's been some talk lately about whether and to what extent agents have the ability to renegotiate their compensation after they already sign a buyer-broker agreement. I think pretty much everybody agrees that if a situation comes up where the buyer can't pay what they previously thought they could pay, the parties are free to amend to reduce the amount of compensation that the buyer's receiving, or sorry, the buyer's broker is receiving. But there's been some more hesitation, I would say, on renegotiating a contract in a way that results in the buyer's broker receiving more.
You mean asking for more compensation than what you originally agreed to, what that maximum amount was?
What that maximum amount is in paragraph 7.
Yeah.
Yeah.
So that has been some conversation, and that conversation is not met with equal opinions. Is that correct? Is that a fair way of saying that?
I think that's absolutely fair.
And in all parties, all stakeholders, I've heard different sides. From the state, from NAR, from buyers and sellers, from brokers, from agents. I've heard people take different sides. What's your opinion, not the legal advice you're giving, what's your opinion on whether, can somebody renegotiate the contract for more commission than what they originally agreed to, yes or no?
I would say yes, but with a caveat. In my opinion, I see no legal prohibition in doing anything that would result in a buyer's broker not being able to renegotiate for more commission, especially in a situation where more is being offered by the listing broker. I would say, however, that you should tread cautiously before pursuing that path. And the reason is that here with the Realtor Association, we have Article 1. Again, you have a duty to protect and promote the interests of your client. Imagine a situation, for instance, where you find out that the listing side is offering more compensation than your buyers agreed to pay, and what could ordinarily be a credit to the buyer, which could theoretically enable them to make a more competitive offer on the front side. You know, if that commission is renegotiated to come back to you as additional compensation, if that results in a less competitive offer and a buyer conceivably loses out on a property because their offer is not as competitive, I think you could very realistically run into some Article 1 concerns there. So while not legally prohibited, ethically I do think it merits some very careful consideration before you go down that path.
Yeah, so my opinion is similar to yours, but for different reasons. I do believe you could renegotiate it up. There's nothing, I agree with you, nothing legally that says you can't. But just because you can, should you? And the answer to that question, to me, is probably, well, it depends, but most probably not. First and foremost, I'm going to tell you, look at what your broker's policies are. Whatever your broker's policy is, stand by that. Second thing I'm going to say to you is make sure that you're not putting yourself in a windfall position. Remember, this is your profession. This isn't playing the lottery. This isn't a game of chance. This isn't a lawsuit or litigation that you're seeking a recovery from. This is your profession, and you've already stated what your value is and what you've agreed to work for. And so if there's a potential windfall, you really should ask yourself, who does that need to benefit? And I can think of very few reasons that the windfall wouldn't benefit the actual parties involved, not those people who are representing the parties. So legally you can do it. Whether you should or shouldn't is a question, a matter of policy and practice for your local broker. I can think of very few reasons why you would. Instead, know your value from the very beginning and negotiate that. Negotiate that and leave yourself room from the very beginning when you enter into that. Enough of that. Let's talk about paragraph 10.
Do we want to touch on subparagraph C here or no?
Oh, I'm sorry, yeah. Did we not? Yeah, we probably need to talk about paragraph C because there's some important stuff in there.
Yeah, no, absolutely. Just very briefly, and this is a situation that is pretty straightforward under the contract, right? So this is the situation where the compensation, if it's offered by the seller or the listing broker, that it is less than what your buyer has already agreed to pay in paragraph 7. Pretty straightforward result, right? You eat at the closing table, the buyer, in accordance with paragraph 7, they get a credit towards what they owe you based on what is being offered or paid by the seller or listing broker, and then the buyer pays the difference at closing. So again, pretty straightforward result there.
Yeah, there is a best practice around this though, and that is to really know what you're willing to do and make sure that you communicate that clearly, right? And so you want the decision as to whether you're going to go view that property and show that property to your buyer to be your buyer's decision. So you're going to determine, let's say you've determined in a scenario, 123 Main Street is offering less commission than what you've agreed to in the buyer's agency form. It's incumbent upon you to have that conversation with the buyer. You should share that information with them as a point of fact, as a matter of fact. I might say something like, an example, before we go show this property, I want to make sure you have all the information and details. Here's your listing report. Here's some tax data on it. Here's some other information you've asked for. In agreement with, in accordance with our agreement that we have, I want you to know that they're only offering, the seller's only offering X% instead of Y%. And so there's a delta there of X dollars, right, of this amount of money. And I just want to make sure that you know that and you understand that. The key to this is you need to still be willing to show the property. Even if there's a delta, even if there's a gap, you should be willing to show that property. You have an obligation to do that, a duty to that client to do that. However, that client may choose and say, well, if there's not enough compensation there, I don't even want to take the time to go see it. It's a competitive market. I've got limited amount of time. I don't even want to get into whether or not I'm going to be asking for concessions or other items like that and selling, so I don't want to see the property. The key to 9C is communicate and to make sure that it's the buyer's decision as to whether or not you're going to go see that particular property or not. Thanks for bringing me back to that one, Jace, because I know that was a one that we really needed to touch on. That's one that could really affect code of ethics and ethics hearings.
Yeah, no, absolutely. The remainder of the OREC residential sale agreement is largely carryover from what it previously was phrased as. There's a couple of points that we want to make regarding paragraphs 10, 11, and 15, but we're going to pass on 12 through 14. So with that, jumping into paragraph 10 here, what does it do? It ensures that the buyer knows that the broker is not going to go about procuring services or goods on that buyer's behalf without the buyer's prior approval of those expenses. Again, there's a best practice here. Try to get that approval in writing and make sure your file is documented in that way.
Yeah, that's it. I think that paragraph 10 gives the agent another opportunity to really demonstrate their value, to be able to say, here's the 179 things that we do for you. Here's a few things that we're not going to do without additional written permission. Just another great place for you to demonstrate value to the buyer.
Yeah, absolutely. Moving on to paragraph 11 here. It ensures that the buyer understands that they are not the only buyer in the market. It ensures that they know and appreciate the fact that you, in representing them, are also working with other buyers. And some of those buyers may well be interested in other property, or with the exact same property that they are interested in. And the same thing would apply to other agents working at your brokerage. So again, it's a disclosure, it's an informative piece that's good for buyers to know.
Yeah, I would consider language around this, and the number one thing I would say is make sure that language is absolutely truthful, right? And so when I'm explaining this paragraph, I would use this again as a mechanism to show my worth and my value. I might say something like, at any given time, our real estate brokerage firm is working with 30 different buyers. Myself as a buyer's agent, I usually limit myself to 2 to 3 buyers at a time. That way I can give those buyers I represent the maximum amount of attention to detail that they each deserve. A statement something like that. Make sure you use right, historically accurate information when you're making it, that you, if you work with 10 buyers at a time, that you're clear that you work with 10. If you only work with 1 at a time, that you emphasize that and point it out. But what it does is it gives a foundation for that buyer to really consider bigger details, like, wow, if it takes 3 to 4 months to get a transaction done and you're only working with 2 people and you're only making X amount of money, maybe what we've learned on HGTV about realtors being the most heavily paid people in the world and making a fortune, maybe that argument is kind of subdued a little bit because they see the reality of what's actually happening.
Yeah, absolutely.
Well, again, we're going to not talk about 12, 13, and 14. I think Jace and I both agree that that is really boilerplate language that everybody should be familiar with. We do want to take a second to talk about paragraph 15, because both from a legal sense and a common sense perspective, this is an area that our agents could get in trouble. So let's talk about some best practices around paragraph 15. What is an additional provision, Jace?
An additional provision would be one that you write in to create extra burdens on one of the parties, extra responsibilities on one of the parties. It could also be a provision where, you know, you step in here and you say, hey, look, paragraph 6 in the aforementioned language is amended as follows. You can use it to amend that language. I would just like to give a bit of caution. There's a lot of power in the parties to create the contract that they want to create here. But that carries with it some big caveats as far as what situations you could find yourself in as a result. I know Hutch has a lot to say about that.
Yeah, what I would say, number one, first and foremost, is that if you're not an attorney licensed to practice law in the state of Oklahoma and working in the capacity of attorney, be extremely cautious about what language you put into paragraph 15. You need to be careful not to practice law. In other words, you need to be careful in what you write to simply and concisely say what you intend or what memorialize what you're agreeing to. I have seen in other states where there's these provisions like this, and real estate practitioners get smart and wise, and they try to write these very well-crafted, lengthy statements that sound like they have a lot of legal ease to them. Don't do that. Don't put yourself or your broker in that position. If you have something that needs to be drafted by an attorney, get your brokerage attorney to draft that language for you. Otherwise, use really clear, concise language. Something like an example of that might be on geography. Like, you might want to limit where this buyer's agency agreement is to take place in. For example, you may have a client moving here from out of state, and they don't know if they want to live in Oklahoma City or in Tulsa. And so you might write into this, if you're an Oklahoma City agent, you might write in, this agreement only applies to properties in the city of Oklahoma City. Period. Something simple, something concise, straight to the point like that. You may have somebody who's considering new construction, and they don't want to be represented by a real estate agent in new construction because they think, hey, I can get a lot better deal if I go straight to it, and that's their belief, right, wrong, or indifferent. That's what they believe, and so they may say, you know, I want you to help me, but not with new construction. A simple phrase like, this agreement does not apply to new construction, is what I mean by being clear and concise.
Yeah, absolutely. I'm trying to think what we've got left here. That's the end of it, folks. Again, this is a situation where there's a lot of industry change happening right now. I'm sure that there's a lot of you that have never used a buyer-broker agreement before and are hesitant in doing so. We believe that our members are competent, that they're resilient, and that they're going to be able to work with these industry changes and persevere through them and be successful. And with that, that's all I've got, Hutch.
Yeah, and I would say as a member benefit of being a part of Oklahoma Realtors, you have access to our legal library and our legal line. And so use that. If you or your brokers have questions, give us a call. That's a member benefit for you. We'll take that call, we'll answer it. You can send an email as well through the website. That'll get routed to our legal department, and somebody is usually back with you with an answer within about 48 hours. Thank you for joining us for this webinar. Jace, thanks for hanging out with me for I think about an hour now and talking through this stuff, and we look forward to serving you as we move forward.